I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The 14th Amendment to the United States Constitution was adopted on July 9, 1868, as one of the Reconstruction Amendments to address citizenship rights and equal protection under the law for former slaves following the Civil War. The amendment was bitterly contested, particularly by the states of the defeated Confederacy, which were forced to ratify it in order to regain representation in Congress. There were 5 sections to the amendment. The first denotes who citizens in America are. It reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." If ever a people have earned full citizenship within their nation of birth, American slave descendants stand in claim of ancestors' payment. Despite slavery's unpaid labor, abuse, murder, and continuous rape, they did and have served a homeland and proudly helped to build it into a great nation. You fought in every war, including the Revolutionary War, while even then being mistreated. When given the option to leave America, go to Africa or Haiti, you said, "No, this is my home." You have pledged allegiance to no other flag and send money to no other country. You are native to America. As the Civil War wound down and America imagined how to rebuild the Union, they entered what was termed the Reconstruction Era. Death, destruction, discard on every side, and millions of former slaves to deal with. Congress had been debating what to do about former slaves freed by the 1863 Emancipation Proclamation, and in 1865 passed the 13th Amendment, the constitutional abolition of slavery. This, however, opened a political dilemma for the very patriots who fought for their freedom, the Republicans, because now each freed person would be counted as a whole person rather than 3/5 of a person to determine state representation to Congress. Most freed persons resided in the South and would greatly tilt representation toward the Democratic-dominated Southern states. What to do? In 1865, Congress passed the Civil Rights Act of 1866, guaranteeing citizenship without regard to race, color, or previous condition of slavery or involuntary servitude. This bill guaranteed equal benefits and access to law, a direct assault on black codes that sought to re-enslave blacks by restricting movement, forced unfair labor contracts, prohibiting them from owning firearms, purchasing property, and preventing them from suing or testifying in court. Congress recommended to President Andrew Johnson to sign the Civil Rights Bill, but he vetoed it instead. Johnson was known to object to the bill because it gave citizenship to freedmen at a time when former Confederate states were not represented in Congress, and that it discriminated in favor of African Americans and against whites. Johnson's veto was overridden and the bill became law. Despite this victory, Republicans pursued a constitutional amendment. Over 70 amendment proposals were drafted, back and forth. Finally, radical Republicans consented to settle for the best that they could get in an agreement. securing civil rights for blacks, but they were disappointed that the amendment would not allow political rights, giving the right to vote. This came later in the 15th Amendment. Citizenship Clause. What does that mean? U.S. Senator Jacob M. Howard from Michigan authored the Citizenship Clause. The Citizenship Clause overruled the Supreme Court's Dred Scott decision that black people were not citizens and could not become citizens nor enjoy the benefits of citizenship. The radical Republicans advanced the amendment to ensure broad civil and human rights protections for the newly freed people. They wanted assurances within the United States Constitution to protect the new Civil Rights Act from being declared unconstitutional by the Supreme Court or future congressional bodies from altering it by a mere majority vote. This was their response to widespread violence against blacks throughout the South happening at the time, lynchings and burnings, killings everywhere. They believed that only a constitutional amendment could protect black people's rights and welfare within those states. Equal Protection Clause. Representative John Bingham of Ohio was the principal author of the Equal Protection Clause. It was created largely in response to the lack of equal protection provided by law in states with black codes. Under black codes, blacks could not sue, give evidence, or be witnesses. They also were punished more harshly than whites. The Supreme Court in Strata v. West Virginia said that the 14th Amendment not only gave citizenship and the privileges of citizenship to persons of color, but it denied to any state the power to withhold from them the equal protection of the laws, and authorized Congress to enforce its provisions by appropriate legislation. In 1880, the Supreme Court stated in the Strata v. West Virginia case, the Equal Protection Clause was designed to assure to the colored race the enjoyment of all the rights under the law as enjoyed by white persons, and it gave to that race the protection of the general government in that enjoyment whenever it should be denied by the states. Birthright Citizenship. Passing the logic test. Birthright citizenship generally means born here, citizen here. That is why a jurisdiction clause is included. I pledge allegiance is fundamental to citizenship in every known nation. Otherwise, you have citizens who may pledge allegiance to their homeland. Native Americans. During the original congressional debate over the 13th Amendment, Senator Jacob N. Howard of Michigan, the author of the Citizenship Clause, described the clause as having the same content, despite different wording, as the earlier Civil Rights Act of 1866, namely, that it excludes Native Americans who maintain their tribal ties and persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers. The Supreme Court held that Native Americans who voluntarily quit their tribes do not automatically gain national citizenship. The issue was resolved with the passage of the Indian Citizenship Act of 1924, which granted full U.S. citizenship to indigenous people. The clause's meaning with regard to a child of immigrants was tested in the United States versus Wong Kim Ark, 1898. The Supreme Court held that under the 14th Amendment, A man born within the United States to Chinese citizens who have a permanent domicile and residence in the United States and are carrying out business in the United States and whose parents were not employed in a diplomatic or other official capacity by a foreign power was a citizen of the United States. Subsequent decisions have applied the principle to the children of foreign nationals of non-Chinese descent. Consider the people of U.S. territory, American Samoa, who are U.S. nationals but not U.S. citizens. American Samoans can apply to become naturalized citizens, but the process is lengthy and costly. In addition, they must live in the United States for 3 months before they can apply. Then they must stay in the United States for months or even years while their application is being processed. During that time, they may not hold a job that requires U.S. citizenship. U.S. territories include the Commonwealth of Puerto Rico, the United States Virgin Islands, Guam, the Commonwealth of Northern Mariana Islands, and American Samoa. More than 4 million people live in them. Except for American Samoa, people born in these territories automatically become U.S. citizens. They have many of the same rights as other U.S. citizens. However, they may not vote for president and they do not pay federal taxes. The greatness of America are the people who come together to pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.